thank you all for joining Bristol Law Society today for a pertinent webinar on landlord and tenant law and managing insolvency risk, particularly important at the moment. I know Edinburgh Wool and Mill are close to appointing administrators again, and given more and more retail shops struggling at the moment, it's a very important topic. I'm delighted to be able to have Mr. Philip Currie here from Forum Chambers to talk about this today. We are hosting this as Bristol Law Society, and thank you all for coming along. We are just on the cusp of, on Monday, celebrating our 250th anniversary, so quite a milestone. We did have big plans, but they've all been put off a little bit because of the pandemic. And we also have an important webinar, if you haven't seen any flyers for it as yet, next Wednesday, as part of Black History Month. We have a webinar which is entitled Allyship for Anti-Racism, What, Why and How, and is being held in association with Burgess Salmon. That's again another lunchtime seminar on the 21st of October. If you do want to sign up to that, then please just have a look at our website or drop our events team an email. And I will now pass over to Mr. Currie to tell us all about managing insolvency risk.
Lovely, thank you very much, Ed. Well, good afternoon, everyone. Thank you very much for coming. I hope to be able to provide you with some interesting information and hopefully some food for thought, so that you can all go away with some better ideas, some further ideas about how insolvency risk can be, or perhaps to the extent to which it can't be, managed in this current time. I suppose, as I was going through this talk, I thought really I should have put a question mark at the end of managing insolvency risk, because as many of you will be aware already, there are so many restrictions on what landlords can and can't do, that there's to some extent not a huge amount of choice they have, but to look at some non-conventional, shall we say, routes to dealing with insolvency and tenants who in particular who are at risk of insolvency. So just to set the structure of the talk, I thought we could go through the legal framework just to remind ourselves of the key bits of legislation which are currently providing restrictions on what landlords in particular can and can't do, and then talk about the practical considerations and the impact that those restrictions have. So in outline, the main routes that a landlord would previously have used would of course been forfeiture and possession proceedings, and they have of course been curtailed significantly by the Coronavirus Act since the beginning of the pandemic, and more recently winding up as an alternative means of, in theory, pressurising tenants into paying, or alternatively, so just bear with me 1 second, I'm having a slight issue with my computer this end. Can everyone still hear me okay? Ed, can you still hear me okay? Yeah?
I can indeed, yeah.
Lovely, thank you. Siri decided to pop up and start repeating my words back to me. Yeah, so as I say, winding up has been somewhat curtailed by the Corporate Insolvency and Governance Act. And as I say, that might have been used as a method to pressurise tenants into paying under threat of winding up, or of course might have actually resulted in a winding up, which eventually would lead to, or would hope at least, some payment towards any arrears. And as I say, we'll move on to some practicalities and alternatives that we are seeing in the marketplace at the moment. So looking just, as I say, by way of recap to some extent, because I'm sure many of you will be familiar with these provisions. They were of course only brought in originally to last until summertime, but they've been extended twice now to the end of the year. So they remain important. So firstly, the right of re-entry or forfeiture for non-payment of rent may not be enforced by action otherwise during the relevant period, which, as I say, now runs until 31st of December. And essentially that is just a blanket ban on simply going in and changing the locks and forfeiting the lease simply because the tenant hasn't paid rent. It doesn't apply to other breaches, though. The point, of course, and I think I said this when I first spoke about landlord and tenant and forfeiture back in, I suppose it would have been around April or May times. At that time I was saying that this right to forfeit is going to kick in again on the 1st of July, but now, of course, I'm saying it kicks back in on the 1st of January. And a tenant who has taken advantage of this provision to avoid forfeiture from effectively, I think it was April quarter when many tenants missed their rent, are going to obviously have significant problems as and when this provision comes to an end, and obviously the longer it stacks up, the worse it's going to get. And so to the extent that there are any tenants out there who, I think the warning has to be, this is not a relief from your rent, the rent is still due, it's simply that the landlord cannot exercise the right of re-entry in respect of it for the time being. One saving grace for landlords, because the concern, of course, would be that there's a risk of implicitly waiving the right to forfeit for these particular arrears of rent which have already accrued by virtue of, for example, having ongoing discussions about the continuation of the tenancy. So anything inconsistent with the idea that the landlord is going to forfeit. And Section 82 goes on to provide that anything short of express waiver in writing will not be regarded as a waiver of the right to forfeit under the relevant tenancies. So some small comfort for landlords there. So the question often raised then is, okay, well, I can't forfeit the lease. What else can I do? Well, the answer is effectively there's a list of various alternatives. There's the possession proceedings, which we'll come back to in a moment. There's the simple Part 7 debt claim. And I'll just comment briefly there that in reality, I'm not seeing, I don't think I've seen any landlords take this up as an option yet. Maybe there's a different experience in the room, but certainly the concern is, well, I've got to pay a fairly sizable issue fee, and then on a timetable to go to a trial. The debt's not really disputed though, so okay, maybe we'll get summary judgment or judgment in default, but then we have to go about enforcing it. And if it is genuinely a question of tenants not being able to pay rather than not being willing to pay, that doesn't really get you anywhere. So the Part 7 debt claim seems a little bit fallen by the wayside for the time being. Two other alternatives, as I say, serving a statutory demand or issuing a winding up petition, often done, as I say, as a threat. The insolvency courts are quite clear that they oughtn't be used as debt collection tactics. They should really be reserved for when there's a genuine belief that the company is insolvent and needs to go through a formal winding up procedure in order to bring it to an end. But of course, if it's a tenant who is playing games and is unwilling to pay, then it's often a statutory demand or a threat to wind up that gets the money to actually come across. But as I say, there's restrictions on those at the moment as well, which again we'll briefly recap so that we are all on the same page there as well. So far as possession proceedings are concerned, then the Coronavirus Act goes on to provide that the court must delay possession until after the relevant period has expired. It's slightly different in the High Court and the County Court. In the High Court, it effectively means that any order will be set after the relevant period has ended. So that relevant period, as I say, is after the 31st of December. And in the County Court, any order made effectively is deemed to be that it won't take effect until after that period has expired. There's some concern about when you're going to get a court hearing. Courts are, as it was the notorious backlog, or the stay and then backlog of various possession and indeed insolvency proceedings. So again, not always the most appealing practically. So that brings us back to the idea of winding up and going through a formal insolvency process of some sort. And this is where we get into difficulties brought about by the Corporate Insolvency and Governance Act. Because this act it's a curious act. It does a couple of things. It brings in some very obviously temporary provisions. So what we're going to look at first in Schedule 10, very obviously a set of temporary provisions designed to last for the period that the pandemic continues having its economic effects, and also some permanent changes. So, as I say, what we're looking at first is set out in Schedule 10. Various other parts actually amend the Insolvency Act, and it appears to be the intention there is that those changes are permanent. But looking at the temporary provisions for the time being, the main set, and this is a little repetitive, so I won't read out everything, but I understand you're going to have a copy of this handout as a PDF afterwards, and that it's also being recorded. So forgive me, rather than drone on to read out what does become quite repetitive. But essentially, in the first instance, there is an absolute prohibition of petitions based on statutory demands being raised on the grounds of inability to pay a debt where it's served during the relevant period. And then there is, I think, the key point to focus on there is simply just to check that this is on the ground specified in paragraph A of section 1231. So for background, section 1231 sets out a list of various different definitions of the phrase inability to pay its debts. And the first one at A is simply that a statutory demand has been served on the company and it has not been able to satisfy that demand. Schedule 10 goes on then to provide certain restrictions, so not absolute prohibitions, but restrictions on winding up petitions and orders. And we have here referencing into section 123, but in this case, sections 123 A to D. And as I say, ground A is the statutory demand. Ground B is if in England and Wales there's been some execution or other process issued on a judgment which is returned unsatisfied, whether in whole or in part. Ground C and D provide equivalent measures for Scotland and Northern Ireland respectively. So this restriction provides that a creditor may not during the relevant period present a petition for the winding up of a company. So this applies to this is a restriction on petitions rather than on making the statutory demand in the first place. But it is a limited restriction because if the condition in subparagraph 2 is met, then you are at liberty to proceed. It's an evidential provision, and we can see from some of the reported cases that the court is being quite cautious on the application of this test. The condition is that the creditor has to have reasonable grounds for believing that coronavirus has not had a financial effect on the company, which I think is probably the most difficult one to satisfy because, I mean, I think almost any company would be able to argue to at least some extent that there had been some financial effect. But also reasonable grounds for believing that, or alternatively rather, reasonable grounds for believing that the facts which give rise to the ground for believing the company is unable to pay its debts would have arisen even if the coronavirus had not had a financial effect on the company. And in practice, that is effectively, we're seeing the distinction there on debts which are very clearly COVID debts. So, for example, I suppose, I think the July quarter date is probably, any rent which fell between, I think, around April time to now might quite easily be said by a company to be coronavirus related, especially if it relates to the period of lockdown during which, let's say, high street shops were forced to close. Where it doesn't work is on debts which have been due for some time. So we've seen examples of companies who have had some debts from, say, April, May, But there are also arrears still from November, December last year. It's very difficult to see how those could be COVID related because no action was being taken in respect of COVID at that time. And so to the extent that those debts would be sufficient, then to show that the company was unable to pay its debts as they fall due, the court is going to be satisfied under this particular test. It goes on, scheduled paragraph 2, to refer to some further grounds. So the restriction also applies if you're relying on ground E in section 1231, or indeed on ground 2. So ground E is simply if it's proved to the satisfaction of the court that the company is able to pay its debts as they fall due. And that's quite commonly used in corporate insolvency. There's no equivalent in personal insolvency, because in personal insolvency you do need a statutory demand. In corporate insolvency you don't. And the court will quite often simply take the fact of a non-payment after a certain period of time as being sufficient, provided that, for example, the debt is not disputed. Subsection 2 provides an alternative definition. So everything listed in subsection 1 could effectively be categorised as a cash flow test. Subsection 2 introduces a balance sheet insolvency test. So effectively, if the assets are less than liabilities, then the company seems to be balance sheet insolvent, and that is sufficient as well, in theory, for presenting a petition. But we have, again, unless the condition in paragraph 4 is met, you won't be able to do so. And paragraph 4 provides a very similar definition as we saw in subparagraph 2. And it's essentially, again, coronavirus has not had a financial effect on the company, or the relevant ground would apply even if coronavirus had not had a financial effect on the company. So again, unless the debt is effectively from before the time of coronavirus, the test is unlikely to be satisfied. And then just to finish off, as I said, it does become a little bit repetitive. But there's similar restrictions on the court's jurisdiction to make a winding up order. And so once it's presented with a petition where the petitioning creditor has, you have to include a statement in the petition saying you have the reasonable belief required by subsections 2 or subsections 4, the court then has to be satisfied effectively that those beliefs are well founded, that the grounds for saying the company is insolvent were arisen in any event. And so effectively what we can see straight away from all of this is that the risk of a tenant going insolvent effectively doesn't lie with the tenant anymore. The tenant has these protections, and of course these don't just apply to landlords presenting winding up petitions, these apply to any creditor. And so it is the landlord and other creditors now who have to continue to bear the burden of a creditor who is not paying. And that is quite a different shift from, I think, where landlords thought they were certainly beforehand, and the complaint is that it effectively has gone too far. And as if that weren't far enough, there was some delay in getting the bill passed. There was certainly a press release quite some time before the bill was going to be, certainly before it became an act. So it didn't become an act, or Schedule 10 didn't come into force at least until June 2020. But it provides the relevant period is backdated to the 27th of April 2020. And it effectively deems that during that period, the court is to be regarded as having had no power to make a winding up order. And so the order has to be regarded as void. There are various other provisions which allow the court on application to make consequent orders to restore the position for the debtor. And also the official receiver has to bring cases of this nature back to court for directions. But I think the interesting thing is that we saw, even in the interim between, I think, the press release saying there was going to be an act which prevented coronavirus debts being the basis for winding up orders. Simply on the basis of that press release, there's at least one reporter's decision, the Travelodge Hotels decision, I think it was Mr. Justice Morgan, who took the view, or maybe I think it's Britt actually, took the view that, well, on the basis of this description, and it was a relatively vague description at the time, it certainly didn't have anywhere near the level of detail we've got now. On the basis of that alone, the court was willing to restrain the making of a winding up order, effectively being unjust because it thought that in due course this would be regarded as a current debt. You wouldn't be able to make it. It's not right to allow you to proceed. I think the underlying, there were some complaints that was unfair because the Act wasn't enforced yet. The court was relying on rules which weren't there, but of course the power to make a winding up order is discretionary in the first place. We saw the same, as many insolvency cases are, a case called Rear Company, where the bill was passing through Parliament, and again, the wording was unlikely to change much at that stage, and again, the court was willing to prevent the making of a winding up order in circumstances where it would be caught by the Act, and in theory, I think in that case, it would have been subject to this retrospective provision. And so the order would have been undone anyway, so there's very little point in putting everyone through the cost and expense of starting the winding up, only then to have to undo it. One additional point to mention from the Act is that there is a standalone moratorium. Now, I said there were some provisions that were temporary, and what we've looked at in Schedule 10 is intended to be temporary, and it had the relevant period to the end of December, but again, subject to extensions. These provisions about the moratorium were introduced by way of amendment to the Insolvency Act itself. And it allows company directors to apply for a moratorium during which no insolvency proceedings can be instituted, and enforcement can only be proceeded with the court's permission. And in the meantime, the moratorium grants the debtor a payment holiday for pre-moratorium debts, except for a list of 6 categories, the most important of which, for today's purposes, is rent for the period of the moratorium. So in theory, this allows companies which are struggling a certain amount of breathing space, even from their landlords, in order to, in theory, put their house in order. The way that directors go about it is simply simply filing documents at court, and if there's no outstanding petition, then the moratorium takes effect automatically. If there's an outstanding petition, then the court can order a moratorium. Again, for the outstanding petition, though, I think you probably have to be in the process of satisfying the court that the debt wasn't a coronavirus debt, so you'd probably be in front of the court at some point in any event. The moratorium is only available for eligible companies, and that effectively excludes a list of companies listed. Realistically, it's only those that are subject to current or recent insolvency procedures, so it prevents companies which are already insolvent or have been, I suppose, circling the drain for some time from taking further advantage of these provisions. And otherwise, we have the idea that this has to be supervised by an insolvency practitioner, who is a newly created role called a monitor. And they have to certify in the documents lodged at court that the moratorium is likely to rescue the company as a going concern. Now, the moratorium only lasts in the first instance for 20 business days. And so if there are sort of quite serious problems, and given the importance and size of rent, delays to rent, I think, are often seen as more significant problems than 20 business days would be sufficient to sort out. It's unlikely, I think, to have a huge impact for landlords. Certainly, I haven't seen any landlords being particularly troubled by this as yet. There are various circumstances in which it can be extended, but it can only be extended once by the directors alone, and otherwise it needs creditor or court permission. And there's also a condition that to get the extension, you have to have paid the moratorium debts. So in reality, an extension isn't much to worry about, because it means, in theory, you would have been paid as the landlord or the creditor. So those are essentially the restrictions, the new restrictions on winding up and liquidation. I mean, in reality, that they aren't always the most attractive, as I say, because they tend to be quite drawn out. The liquidators obviously need to be paid themselves out of the assets of the company, and there's therefore a dilution for when a dividend comes out the other end. But in theory, what it does do is allow landlords to get their premises back sooner than they might otherwise. The alternatives, for example, administration, provide for a moratorium on insolvency proceedings, but also a moratorium on other legal process, which includes forfeiture. And so there's obviously some concern that this won't get properties back in the hands of the landlords. But what it does do in theory is, to the extent the tenant is still using the premises through the administration, in theory rent has to be paid. And in theory allows for, as I say, rent to still be paid to the landlord, and it is seen, I think, as the certainly not the worst outcome in terms of insolvency processes. The benefit, or it's not benefit, I suppose one of the concerns that we're seeing raised, this idea of light touch administrations. I think both Debenhams and I think Carluccio's as well was also described as a light touch administration. And I think the concern there is that the directors are largely left to their own devices for the day-to-day running of the company. And that obviously is for the company of benefit. In theory, it allows those who have the closest interactions with the company to be able to try and rescue it. But for creditors, the concern, of course, is that, well, if they're still the same people who ran it into debt in the first place are still running it, we're not really going to get much further. But we are seeing a number of administrations for high street premises, as I say, some described as light touch, in the hope that they won't last too long, they won't have too devastating a consequence. But I think the longer this goes on, perhaps the less likely that is. Another alternative is the CVA. I spoke for Bristol Society just about a year ago, I think, on CVAs, because they were, throughout 2018 and through the first half of 2019, they were so prevalent for, in particular, high street chains. And there were obviously a number of high profile ones. We'll come back to the Arcadia group for some interesting comments at the time. And what we see effectively is that typically affects landlords the most. So again, we see, even through formal insolvency processes, the risk of tenants running out of money is being brought to bear significantly on landlords. And I say landlords are typically affected the most is because, of course, rent is often the largest cost, and it's often fixed. And of course, if your shop is closed, or even now that they're open again for the time being, there's obviously significantly less footfall. A fixed rent cost is obviously difficult for tenants. In theory, a CVA should be a benefit to everyone, because it is, to some extent at least, negotiated. It is supposed to be an agreement. And it is supposed to provide a better outcome, in theory, at least overall, than administration or liquidation. The concern, of course, from landlords is that they are being abused. And this was a concern in 2018-19 when very many were being put in, which effectively only really sought to cut rent. Very little was being done to other creditors. Compare that to, say, an administration or liquidation, where all creditors are, at least unsecured creditors, are affected equally. As I said, the Arcadia proposal was something, I think it was something effective in some cases of 70% off of various, I think Topshop in particular was singled out. And the landlords, or some of the landlords at least, were concerned that, well, if we've got to give, I might have a shopping centre of some description with a couple of arcade shops, if I'm giving 70% off to those tenants, aren't all tenants going to want the same? And the response was from tenants was effectively that landlords are clinging to what they refer to as an out-of-date rent model and rent levels. I think Arcadia threw up a lot of frustration because of the individuals involved, but I don't think we need to say any more than that. But effectively, CVAs in particular, as they affect landlords, I mean, the best case is that you'll retain the same level of rent and see a shift from, say, quarterly to monthly. So you're getting paid small amount, more frequently, easier in theory to notice when a tenant is in default, and have the supervisor shift into administration liquidation as needs be. The worst case is requests to reduce rent to as low as nothing, which obviously entirely shifts, well, reduces rent to nil and shifts rates liability to the landlords. The sort of middle ground between that, I think it's something that we're starting to see, or we have started to see a few requests on this basis over the summer, is a request to shift to turnover rents. And again, it does shift the risk of insolvency, or at least the risk of the extent of commercial success, onto the landlord. The amount of rent being paid being linked to the tenant's trading performance. So the more your tenant turns over, the more you get in rent. That, of course, means that while shops are open but trading less, I suppose it takes the fixed nature of rent out of the equation, making it variable based on turnover. Obviously helps tenants in managing their cash flows, but obviously is difficult for landlords because their cash flow is necessarily unpredictable. And of course, if there is, for example, a further lockdown where shops are closed and obviously trading stops, that isn't a liability the tenants have to bear. It is a risk on the landlords of receiving nothing. The argument, I think, is that we're in unprecedented times and therefore we are effectively sharing the burden and the risk of not having any income. And I suppose we can test that, I suppose, by reference to an example which is in the press recently, which was the New Look CVA, where I think the request was for hundreds of its stores to move to a turnover-based rent model, and for a handful of others to have a straightforward rent holiday. The concession to the landlord, I think, was that the landlord got enhanced break provisions. But the threat was that if we don't do this, then effectively the company's going to collapse. There'll be, I think it's 11,000 jobs being lost. And of course, the risk to the landlord is then that they have hundreds and hundreds of entirely empty stores. So the carrot is, well, it's better to have a little bit of rent than it is to have no rent. The extent to which that's true, of course, depends on market conditions. And I'm sure you appreciate that there's not as yet an enormous list of tenants clamouring to get back into office and retail space. So how, in practical terms, are the relationships between landlord and tenants being managed? Well, one of the things the government did was publish its Commercial Property Code of Practice, which is a little bit on the vague side, I think it's fair to say, in many respects. And of course, it's voluntary. In fairness, it isn't supposed to prescribe what should happen in any given set of circumstances. It is supposed to encourage landlords and tenants to work together. And effectively, the tenant is requested to be transparent and open and upfront about the difficulties that it's facing, explaining effectively why, if they're asking for any concessions, exactly why those needs come about, what the financial circumstances are, provide that information to the landlord so that the landlord gets a clear picture of where the tenant is at financially. So on behalf of landlords, that is of course something to be seeking from tenants, because I mean, we have seen some tenants who are effectively just being quite cheeky and saying, COVID, I can't pay my rent. And of course, that is not a logical argument for saying, I can't afford to pay my rent because coronavirus has impacted me in X, Y, and Z ways, which is something I think any landlord would want before simply accepting there's a virus as an excuse. And then the encouragement on landlords is to effectively to provide concessions where they reasonably can. Obviously, they have their own financial commitments, which they're entitled to take into account still. But any response which says, no, you're not getting concessions should be clear and explain to tenants why that is. And there are some specific steps which effectively come out of the code, which encourage landlords effectively to look at splitting rent during lockdown. So not dissimilar to the idea of rent reductions and the rent splits and reductions that you see in, for example, CVAs, but obviously linked not to an arbitrary period of a number of years for the purpose of restructuring, but simply to reflect lockdown. Of course, that addresses the very immediate problem of the cessation of cash flow for tenants. To the extent that any arrears has been maintained, then affordable payment plans should be encouraged, and rent reductions, so outright rent writing off of rent, should be looked at where appropriate. Now, of course, for the lawyers on the call, there'll be a number of alarm bells ringing about any requests for concessions, etc. And in the first instance, it will be, of course, what has actually been agreed. And so, of course, encouraging to get these agreements down in writing, hopefully with the input of a lawyer to the extent it's necessary, so that everyone knows exactly what has been agreed and there'll be no argument about it later, because I'm sure, he says with his litigator's hat on, I'm sure no one wants to be having arguments about what was and wasn't agreed further down the line. I suppose the other concerns are that these are not going to be sort of one-off talks. There's no immediate end in sight to the pandemic, and of course we see in the news frequently various administrations and sections of government are talking about various different sets of restrictions and even a second nationwide lockdown. Of course, what might have been agreed, say, a month ago, on the basis that there was something of an uptick over the summer in terms of economic activity and footfall, is not the situation that we're going to see in perhaps a month's time. And so there's a concern about these being very much short-term solutions that are going to have to be constantly revisited. And I wanted to sort of end with just a couple of examples that we've seen. One from one I picked up on in the press, and one that we've seen ourselves for a number of times now. May have seen that Grosvenor Estate encouraged or assisted its restaurant tenants to extend their Eat Out to Help Out scheme beyond August through a rent reduction. So to the extent that any of these restaurants in the West End carried on offering the up to £10 off, they would get that back from Grosvenor in a rent reduction. So there we have the tenant effectively still gets the benefit of the meals it sells, and the landlord is bearing the burden there. And I think that was widely perceived as very helpful, but relatively, I suppose, in the grand scheme of things, inexpensive way to go about addressing an issue to that particular sector. And this is something we've seen in particular for office space, so flexible office space on shorter term licenses or tenancies, so-called COVID clauses. And effectively what they do is say that if there is, I mean, the wording that we were playing around with a few weeks back was, if there is a further lockdown which affects the particular city or region you're in, then your rent will be reduced by a certain percentage, pre-agreed, so everyone knows what it is, and it will that reduction will last for a maximum period of, say, 2 months, 3 months, depending on negotiations. And to the extent there's that reduction for whatever period of time, there will be an equivalent extension to the period of the lease. So the landlord gets at least some comfort that although they're going to have to take a knock for those, say, 2 or 3 months, in theory, at the back end, they've got 2 or 3 months of knowing that in theory, subject to insolvency, of course, I suppose, that there'll be a tenant at the end to carry on paying. These, I think, are fairly helpful. I think they give tenants some comfort, especially in circumstances where we've seen sort of tenants reluctant to go back into office spaces. But of course, I think there's probably a lot of downsizing to look at. And I think this is where we may see these sorts of clauses being negotiated more and more. Again, word of warning, I suppose, is make sure that they are specific. There's reference, I think, in the code to simply if there's a lockdown, but I think given that we've now got our 3-tier structure, it might be that you're able to be more specific about what trigger events might be for these sorts of extensions. But as I say, they're just they're two of the main examples that we've sort of seen, certainly in practice, because as I say, on the face of it, the landlord's options are severely limited, so a bit of alternative thinking is required. There ends the presentation. I understand that we've got time for some questions and answers.
We do indeed. We've had a couple of in, and a little chat pop-up just appeared from Claire. Thanks, Claire. Just reminding everyone, if you do have any questions, to send those through on the question and answer button at the bottom of the screen. Fortunately, we already have a couple of in. So, Phil, can a landlord forfeit a lease by re-entry when the commercial tenant is subject to a creditor's voluntary liquidation? Is the landlord precluded as a creditor to the company or within his rights as a proprietor of the land?
So I think the key there is you said creditor of the company. Presumably yes. That's rent arrears, in which case the restriction in the Coronavirus Act would apply, I think. But otherwise, you said it's creditors voluntary liquidation, right? I think otherwise, I don't think there is any particular restriction. Yes, I think it's the other way around. In creditors, I think there's the ability of a liquidator to apply to prevent action being taken, which would apply generally to legal process, and I think also applies to forfeiture. But no, unlike, for example, administration, where it's specifically excluded, there's a specific prohibition on forfeiture, whether it's for rent arrears or, for example, it's not uncommon to have a clause which says if you go into CVA, administration, liquidation, will be entitled to forfeit. In administration in particular, for example, Schedule B1 provides a restriction on forfeiture in those circumstances.
Okay. Anecdotally and from your experience, are courts being more inflexible towards landlords who aren't willing to share the tenant's pain?
What in terms of, we're in court, what, on a winding up petition, say? This might be the first hearing.
Or a Part 7 debt, I'm assuming.
Yeah. Certainly from the winding up list, I've seen there's a little bit more willingness to give time. If it's a very, very old debt, you may have seen that Macclesfield Town Football Club recently got wound up. I am the solicitor referred to in one or two of the press reports, but that debt was, it was 18, I think it was 18 months pre-COVID already. HMRC had been on and off the petition, and the judge was very much, this is the 8th hearing or something, we are entirely not interested. But if it's a landlord who's saying, well, okay, the debt is a bit old, it's not a COVID debt, but the excuse is, well, we are trying to pay the debt down, we're paying it down a little bit, we could only pay it down more if COVID was not having such an impact. I think as long as the tenants have some sort of plan, something that they can reasonably say they're doing to try and get the debt paid down, that to some extent is succeeding. I've seen some fairly lengthy extensions granted. But of course, if it's a COVID debt, we're not getting there in the first place. So it is at this stage, by definition, we're only really dealing with debts that are from at least, 10 months old or thereabouts. And if it's a case that the tenant is just not in a position and is never going to be in a position to pay them, then it's better not to delay the inevitable, even if that is a landlord who's got their finger on the trigger.
And then coronavirus related, less insolvency wise, but at what point is a side letter in a rent reduction during this period and a landlord sharing the pain, is that going to start impacting on the market rent in a 1954 Act renewal? Is that a market concern?
I think it is. I mean, actually, 54 Act's in it because I think there's also a provision in the Coronavirus Act, isn't there, which says that you can't use COVID debts as an excuse for non-renewal. So already there's a bit of a market shift there in terms of where the power is. Yeah, I mean, I've already seen on the sort of the short, flexible office licenses, rents are markedly moving down, and I've seen clients who've even had landlords come to them saying, "I know you made us this offer, and then we rejected it, 6 months ago, but actually, can we revisit that?" And not only revisiting it, but volunteering additional, rent-free periods, COVID clauses. So I think if you are a tenant looking for, as I say, I've only seen it in relation to office space, but if you are, and I don't suppose it would be hugely different for retail, if you are looking for it, I suspect that pressure is only working in your favour at the moment. Obviously, it's a very risky time, commercially, to be doing it, especially with rumours, as I say, of second national lockdown or what have you. But yeah, we've definitely seen a number of examples of those sorts of conversations. Yeah.
I can't see that we have any more questions. So unless anyone wants to fling a hand up or anything and jump in, I will just take this opportunity to thank you very much, Philip, for your time.
My pleasure.
Thank you all for sacrificing your virtual lunch break, I'm assuming it will be. And a reminder again to check out all of our events and seminars. This is going to be part of our property litigation, so there will be more property litigation seminars throughout winter to keep your spirits up when the evenings get darker and gloomier, or something like that anyway. Thank you very much for attending, and thank you again, Phil. And
no, pleasure. Thank you all.